The first part of my talk today is really probably a rehash of the current situation and probably general principles. And then I'm leaving it to Shari to do the difficult part, which is discussing how the new transfer balance cap affects traditional estate planning strategies and the effect that has on your super strategy over the longer term and of course upon your death. So I'll just go through a number of concepts. I'll start off by saying that I don't understand why, but super has been made so complex and so convoluted that if many of you in the audience find it difficult and confusing, or you're in good company because most of us do, and it takes a lot of effort on all of our parts, including your professionals, to make sure that we understand it correctly. And there's a lot of, unfortunately, bad advice out there when it comes to superannuation, and a lot of bad advice when it comes to estate planning. Traditionally, the will was the place where the majority of your assets pass through and pass down to the next generation. That is clearly no longer the case. So any legal practitioner who focuses solely on your will is generally not doing their job properly, particularly those with significant amount of assets in super. So that's probably the prelude for my talk today. Feel free to stop me as I'm going through and ask any questions. Absolutely fine. In fact, in some ways it works better if people are interactive. I'm sure other people in the room are thinking the same thing. So I won't be offended at all. And likewise, if anyone, it is a bit warm in here, I know you've had a few drinks, if anyone needs to duck out and go to the toilet during my talk, I won't be offended. I'm sure you can catch up when you come back in. So superannuation, I'll just get my slides in front of me. Actually, I'll just say just something, a little bit about my background. I grew up in Port Lincoln, came to Adelaide for boarding school, and then did various things and ended back up in Port Lincoln in practice with my father in 2009, who's also a lawyer. And then that firm was called Jenkins Anderson, and we merged in with Mellor Olsen in 2013. So the Clare and the Port Lincoln offices that you saw on the screen before were our offices. And I suppose the reason why we approached Mellor's to join them was because of their regional focus. We thought it was a good fit for us, and it's certainly proven to be. I'm now in Adelaide running the estate and succession planning team, of which the lawyers here tonight are members of. So I've relocated to Adelaide. I miss Port Lincoln, but hoping to do good things over here as well. So there's a number of cashing events. Death is a compulsory cashing event. So the base position for the law is that upon your death, the super in your account balance has to come out to one or more persons or your estate. So there is quite a lot of confusion amongst some people that those with self-managed super funds where you've got effectively a pooled group of investments. Upon the death of one of you, the balance doesn't sort of just go across to the other person within the fund like it would do in other structures such as family trusts. That portion that is attached to your name within the fund is yours alone and has to come out in one form or another. A lot of super funds and many non-self-managed funds, industry funds and retail funds have compulsory superannuation, which is again something that's probably not very well understood. So for many of you, your children, if they've had 2 or 3 jobs in their younger days, or you have yourself and you've got multiple funds, quite often there's quite a large pool of money there that people don't realise. So quite often I'll say, well, my son needs a will, but he doesn't have any assets. And then we go through the process and he's got three super funds because he didn't give the employer the details of the last one. There's $200,000 in each one of these funds, and he's actually worth $600,000 if he died. So what happens with life insurance within superannuation is that it comes into the fund and forms part of what's called the death benefit, which is effectively your account balance as of your date of death, and then it just gets added to that and combined that becomes a death benefit. So in the slide you'll hear there'll be death benefit referred to, and that's what that means. So super can be paid to a deceased dependents as either or both of an income stream. So that's slightly different to your current pensions if you have a current pension, or a lump sum. And I'll go through that in a little bit more detail. If it's paid to a non-dependent, and I'll go through the definition of dependents and non-dependents shortly, it must be a lump sum. So superannuation balance getting paid to an estate, for instance, so getting paid to your executors to be dealt with by your will, it must come as a lump sum. So it can't be paid out as a pension to your estate or to those who are non-dependents.
John, can I ask a quick question?
Yeah, sure.
Do all your comments apply whether it's a company structure or just a plain super fund? Or are
They do, yeah. So all of what I talk about today will apply to self-managed funds as well as retail and industry funds.
Funds are a company?
Yes.
Or do they stay non-company?
Yeah, it'll apply to both. Yeah, so the difference, and I'll speak about the trustee further on in the speech. So yeah, that will apply to both. So very helpfully, there's two different definitions of dependence. I won't stand here and try to explain why that is the case, but there's two different definitions, one under superannuation law and then one under taxation law. And the two don't match up perfectly. They've got similarities, but they don't match up perfectly, and I'll explain to that in a second. And effectively, the two definitions firstly determine who can receive your super at all from your super fund. And secondly, if that person does receive the super, how that superannuation balance is treated for tax purposes. And then any payment from the super fund, whether it's to an individual or your estate, is subject to what's called an auto-reversionary pension, which I'll deal with further on in the speech as well. So, this is probably the most technical part of my talk tonight, but under superannuation law, and that determines who can actually receive your super in the first place. Obviously, a spouse is a dependent, a child of any age, and a person with an independency relationship with the deceased. Now, interdependency is a reasonably broad term that effectively means that someone is reliant on that person for financial assistance. Whether it's an interdependency relationship or not is really dependent on the facts, and every single set of facts is different. So we have argued some relatively, complex and unique circumstances to say that someone was in an interdependency relationship. So that is a reasonably broad concept, but it's probably not commonly used. So that means that any of those people can receive super. So you can pass super down directly from the fund to those people. But then under taxation law, a dependent is the spouse or a de facto spouse, a former spouse or a former de facto spouse, a child of the deceased, but the child has to be under 18 years of age, a person financially dependent on the deceased, or a person with an interdependency relationship, as I talked about before. It's a little bit of a complex concept for children that are over 18 but still at home. The general rule is if the person's 25 or under and they're still at home and they're going to uni and you're still supporting them and doing their washing and cooking the meals, they will be a dependent under taxation law purposes. But as soon as they move out of home or they've got their own job and they're living in the granny flat out the back, they wouldn't be considered to be a dependent for taxation purposes. So the simple rule is death benefit paid to a tax dependent is tax-free, and a death benefit paid to a non-tax dependent is subject to tax on the taxable component. Now, I imagine many of you are probably familiar with the differences between the taxable components within your super fund and the non-taxable component, and I'm sure Shari and Michael and others discussed with you, taking steps to try and convert taxable parts of your super fund to non-taxable. So, but it really comes home to roost once you've got adult children, because they are no longer tax dependents once they turn 18, but in many cases 25. So certainly once they've turned 25, there will be tax consequences if they receive superannuation. And I suppose, yes.
I just want to get it clear on that. I
on the definition up the front where it says a dependent includes the deceased spouse or de facto spouse and a child of the deceased in any age. Do those people actually have to be financially dependent on the person who's died?
No, they don't.
Okay.
Not to receive the super,
Yeah.
but if they want to receive the super tax-free, then yes, they have to be financially dependent and under the age of 25.
Yeah, oh, okay. I won't take it any further, but that's terribly confusing.
It is very confusing.
If they want to engage me to get the definitions right, just ask them.
Okay.
Sounds like a pretty pathetic question, but so I've got a 23-year-old who's not dependent upon me to do his washing for him. Which law applies? Is it the super law or the tax law?
Well, both, and that's the confusing part. So it's a two-step process. You firstly say, can this person receive a death benefit from a super fund? So are they a dependent or a non-dependent under superannuation? Are they a dependent under superannuation law?
So the answer is yes to that.
Yes, he is a child, so he can receive it. The second point is, will he receive it tax-free? And the answer to that second question will be no, he's not a tax dependent for taxation law. So yes, he can receive it, but there may be tax consequences of him doing so. So I guess where that sort of feeds into your estate planning strategy, and I get this a lot. In fact, I was giving advice on this only yesterday, where someone with the best intentions wanted to give her superannuation to her two daughters. Husband and wife were there was no issues. The husband was going to be financially secure without her superannuation. And she just thought, oh, that'd be a nice thing to do. I think her balance was about $500,000. I'll give my superannuation to my adult daughters. But I obviously had to point out that the result of that, and she had a reasonable portion, I can't remember the exact number, but a very large portion of her super balance was taxable. So if she had have continued with that strategy and paid her death benefit to her adult daughters, 15% tax would have been taken out on that balance. Where if she had have passed it to her husband, he would receive it tax-free. So the advice ended up being, and there's no issues with the family, and this isn't always the case, but the advice was he can receive it tax-free, and then he can give it to the daughters. So that was the agreement that they've now made, saving themselves, several tens of thousands of dollars in tax.
Joe?
Yes.
I'm just wondering, what about a sibling? What does that come under, a dependent or non-dependent?
Very good question, and I sort of deal with that on the next slide. So, in most cases, with the caveat that this won't apply if someone is with an interdependency relationship with you. So, assuming they don't have an interdependency relationship with you, they can't receive it direct from the super fund. So that includes parents, which is something that can't happen. Siblings, grandchildren is probably a really, really common one that we see. I see a lot of death benefit nominations giving the grandkids the super. It can't happen. Unless the grandkids are financially dependent on you. So there's always that caveat. So if you are actually the parent effectively of the grandchildren, it's a different situation. But in most ordinary cases, grandchildren can't receive it. Neither can your best mate from the pub. And very unfortunately for me, your lawyer, if you're inclined to give it to me.
So what does that mean then, if you do have a sibling involved in super
Yes.
in the will, does that make it then a dependent and there's tax-free, or is it non-dependent and tax?
Another good question. So my next point there, if it's paid to the estate, so the way to get around those restrictions is to not have it paid directly from the super fund. So the super fund trustee, whether it's your own trustee if you're a self-managed fund, or if it's a trustee of a retail or an industry fund, they've only got two options. They can pay it to a superannuation dependent, or they can pay it to your estate. So there's obviously people out there who don't have a spouse or children or any of those other categories. So there needs to be a place for the super to go. So they have to pay it to the estate. Once it comes into your estate, your will can dictate whoever it goes. Then you can give it to me, if you like. But what happens with taxation is that there's a look-through approach. So even if it did come into the will, and there's many reasons why we do send the super into the will, principally to utilise a testamentary trust, which many of you may be familiar with. If it does come into the will and then gets effectively distributed to someone who is a tax dependent, it's a look-through approach. So you'll still get the same taxation outcome. If it goes through, say, into your estate and then goes to a sibling who's not a tax dependent, there will be tax paid on the taxable component. There is one slight good news: if you pay it to the estate, you don't have to pay the Medicare levy, so you save 2%. So that's one advantage. Yes.
Just a small part of that. Is the super taxable benefit or income added to their taxable income, or is there a flat 15% of that taxable component they have to pay?
Yeah, good question. It's a 15% payable on the death benefit.
Regardless of what their income
Correct.
or taxation
Yeah,
is.
so if they had $1 million worth of income in their own right, it wouldn't matter, they'd still be taxed 15%. Well, sorry, 17% with the Medicare levy, it goes direct from the fund.
Where is the tax accounted for?
It's accounted for by the deceased in the final deceased tax return, I think. Shari, is that correct? Yep. So when someone dies, you generally lodge 2 tax returns. You lodge a date of death return for the income from the 1st of July up until the date of death. And then you'll also generally lodge an estate return for the income that's generated by the estate during the period of death and when the estate is finally distributed. So there's 2 tax points of tax returns that are lodged in relation to that. If an estate drags on, you'll have to lodge multiple tax returns until it's finally dealt with. And just a sort of a slight caveat, if you want to be able to receive, so the super trustee can, once a person dies, there's the death benefit that sits there. Generally, the rules allow for, and I say generally because every single trust, every single super fund is different depending on the governing rules. So there is a huge variation in what can happen under the rules. So there's governing legislation, but from there, the trustee that governs your super fund determines exactly how those rules are applied. But to receive an income stream, so that the death benefit can be paid instead of, let's say it's $1 million comes in as a death benefit, the trustee of the super fund, even if there's not a pension in place at the time, the trustee of the super fund can say, well, I'm going to pay it to child X and I'm going to pay it as an income stream, or I'm going to pay it to the spouse as an income stream rather than as a lump sum. So in my $1 million example before, that $1 million would be invested and an income stream would be paid to pay out that death benefit, and then upon the death of the person who was receiving the income stream, that would then form part of their estate and be distributed by their will. Although I'll make mention of a sort of a variation to that strategy a bit later. So in relation to income streams, there are fairly complex tax rules, as you'd imagine. If one or either of the deceased or the recipient of an income stream is over 60, then everything's tax-free. There's usually not a lot of untaxed element. Shari, am I correct in saying that as well? There's not a lot of untaxed element generally.
No, sometimes that's life insurance proceeds.
Yeah. Yeah. So, that is a good example. So life insurance proceeds are an untaxed element, so that will be subject to 15%. So the 10% with the marginal offset. If the deceased and the recipient are under 60, then the beneficiary's marginal rates with a 15% tax offset will be paid in relation to the income stream.
What's happened if the deceased is over 60 and the recipient under 60? Yeah, oh, sure. So what happened with the deceased over 60 and the recipient under 60, which I thought would be a very common case?
Yeah, it's tax-free if the deceased was over 60.
Okay.
Yeah. Now, many of you may have reversionary pensions in place. Effectively, a reversionary pension is a pension that's getting paid to a person at the moment, and then when that person dies, there's a direction in the terms of the pension that says, upon my death, my pension continues to be paid from my balance, and it gets paid to a recipient. So the most common, obviously, is between spouses. It says, okay, well, I'm earning, I'm drawing $100,000 from my super fund as a pension each year. Upon my death, I want that to revert to my wife or husband. And nothing really has to change in terms of the fund, subject to being below the transfer balance cap. So That's where Sharia will come in a minute. But let's say two people have $500,000 each in, and they're both in pension phase, drawing a pension from those balances. Upon the death of one of them, that pension can continue to be paid to the survivor. And there's two versions. The most common version is what's called auto-reversionary, which means that it just happens as a matter of course. So the rules, when the pension is set up, say, if I die, my pension goes to my wife or to my husband. There is a variation to that, which we see, which says, if I die, my trustee may pay my pension to my spouse or my husband. So it's the may that becomes a slight variance on that. The Commissioner for Taxation treats them slightly differently. An auto-reversionary pension has to be dealt with within 12 months of death because it effectively gets allocated to your transfer balance cap. If there's some sort of discretion, then it's allocated to your cap upon that determination being made. So if there is discretion, the trustee says, yes, I'm going to determine to make it that pension continue on to the wife or husband. At that point in time, it gets sort of brought to account. And that's subject to the general requirement that you must administer a super fund in a reasonable amount of time, so as quickly as you can. Written terms, they don't need to be sort of encyclopedias by any stretch, but making it clear within your terms that the pension is reversionary and the fact that it's an automatic reversion is important. So that's hopefully a bit of an overview of the way that super works upon your death. It then feeds into my next topic, which is enduring powers of attorney. Many of you would have enduring powers of attorney. There's two types: a general power of attorney, which can operate while someone still has capacity. So, for instance, I was living in Sydney. My uncle was living in the US. He wanted to sell a house in Sydney. He appointed me his general attorney to sell his house. I sold his house for him, and upon I think it was a time period, 4 months or whatever it was, that authority was revoked, and he went on with his normal affairs. The more common one, and certainly the more common one for estate planning, is what's called an enduring power of attorney, which obviously gives someone the ability to look after your affairs after you lose capacity. So if it got to the stage where you might have had a stroke or you've suffered from dementia, somebody can then look after your affairs and stand in your shoes from that point in time. There's sort of two ways that you can deal with enduring power of attorney. You can have it so it's exercisable immediately. You might say, look, I'm perfectly fine, but I'm getting pretty sick of having to look after all these affairs, son or daughter or best friend or whoever it is. I'll sign my authority over to you and you just look after all my affairs. I'm not interested. You can do that. Or the more common scenario is that it only becomes applicable upon you losing capacity. So the way that works is that the person who's been appointed the power of attorney would need to have with that document a letter from a doctor or an assessment from a doctor which says that the person is incapacitated. So you take the power of attorney with the confirmation the person is incapacitated to a bank or to the Lands Titles Office, etc., to prove that you've got the authority to then act on that person's behalf. The terms of powers of attorney can be very broad. I think they should be as broad as possible, or they can be relatively restrictive. So I guess a common restriction that we use is, say, in relation to appointing two attorneys at the same time, you can have it so that either one of the attorneys can make decisions up to a certain amount, say $5,000, but if you want a little added level of protection, anything over $5,000 requires two people to approve the transaction. So that you can really be quite flexible with the way that you can tailor a power of attorney. In my view, it's really important that your power of attorney has specific powers in relation to superannuation. It's debatable, and Jenny and I were sort of talking about this yesterday. I think you can mount an argument that a broad power of attorney should allow you, depending on the terms of the deed, to do some things within super. But having very specific powers in your power of attorney about what you can do with a super fund, I think is really important. So the main things there that we see, and I've been a part of this in real time, if you're the surviving person of a couple, for instance, and your super is going to be going to your children who are adults, again, we're subject to that 15% tax on the taxable component. But if you've reached the eligible age or the conditions of release, you can actually withdraw your super tax-free. So I was actually the attorney in this case, which was a little bit unusual, but I had a very wealthy doctor as a client. He had about $3 million worth of super in his super account. He was looking like his time was just about up. And me and his accountant, who were the attorneys, we signed a declaration that he was withdrawing his super. We did that about 5 o'clock one day, and he died overnight. And I think we worked out the saving was about $380,000 that we saved for the beneficiaries by withdrawing the super. So that's a good example about how important it can be. The second part is if someone's a trustee, an individual trustee of a super fund, someone who's been appointed their attorney can become a trustee to administer the fund, and they can also, if you've got a corporate trustee, they can also become a director of the super fund in place of a person who loses capacity. Yes?
In that example you just gave, is there a limit on how much a child, one of the children of that doctor, can receive tax-free as a gift in 1 year? For example, you drew down $3 million. I don't know how many children were going to get that or a spouse. Is there any limit? Can you give your children $1 million just like that?
You can.
You can.
Yep, so there's no tax consequences with gifts. Well, the only real consequences with gifts is for Centrelink purposes. So you then have to account for Centrelink being the recipient. So obviously if you're in receipt of a Centrelink benefit and you get given $1 million, you have to tell Centrelink that you just got given $1 million. You're generally not going to be eligible. And it's also, and a lot of people ask this question, I want to receive a Centrelink benefit, can I just give away all my assets to my kids? Well, no, you can't. So there's a limit on the amount you can give away in any year for Centrelink. So they basically say you can give away $10,000 each year. So you can give away the $1 million, but they're only going to credit you for $10,000, 20 in the second year, 30, 40, and then 50,000. And then after the fifth year, then it's considered to be completely gone. So it's generally a 5-year strategy for giving away assets if you want to make yourself eligible for Centrelink purposes. But for the recipient, there's no tax consequences.
And Joe, I don't want to lengthen proceedings, but it's probably also worth noting that there are some interesting cases now about the use of the power of attorney and the general rules about conflicts of interest. That's a whole separate seminar topic, but there are some things you can and can't do because there are other rules that sit over the top, like conflicts.
Yeah, very good point. There's some cases, a lot of cases sort of bubbling away at the moment. One is on conflicts of interest. The other is how far an attorney, what sort of things an attorney can do for somebody if they've lost capacity. There was a recent case that said that a person can, there's a lot of binding nominations, which I'll come to, lapse. And there was a case recently that said that attorney can reignite an existing lapsed binding nomination, but can't create a new binding nomination. So if I'm the attorney and become the trustee of if I'm the attorney for my father, I've got 4 siblings, I can't then say I'm going to do a binding nomination to myself. That's, at the moment, the way the case law sits is that wouldn't be permitted. But if my father had a binding nomination in favour of me, I could renew that binding nomination and make sure I still get all the super. So the common uses, paying bills is probably the most common day-to-day type of use for an attorney. Selling property is a big one as well, particularly with aged care. A lot of people have to sell their property to get into aged care. Sign a residence contract for care. So that sort of interacts with, you would have heard of what used to be called an enduring power of guardianship, which is now called an advanced care directive. So the person who you appointed under your advanced care directive for health decisions is called a substitute decision maker. That person, it's a sort of an interaction with your attorney. That person decides what care home you're going to go to. So they're going to say, well, I really like Lords Valley. We're going to send mum or dad there. But then it's the attorney that actually has to sign the contract with Lords Valley because that's a legal process, not a medical decision. So the two sort of interact with each other. And withdraw super, as we just talked about. Trustees. This is a pretty critical part, and there's a reasonable amount of rules in relation to trustees. So this applies for self-managed funds only. Your retail fund or your industry fund or your government fund will have an appointed trustee, and there's nothing you can do about changing that trustee. That you just have to put up with that. But for self-managed super funds, you can have 4 individuals as trustees. It's going to be 6 if the changes come into force, or you can have a company. And obviously a trustee is responsible for administering the fund. So that they're the legal face of the super fund, but the actual beneficial ownership still sits within the fund itself for the benefit of the members of the fund. So they're just really, well, you often see nominee as, you know, when in the name of a company, because they're really just the face, they're the legal face of the fund without actually having any ownership in the assets itself. So all members must be individual trustees or a director of the trustee company. The only sort of difference there is that if you're incapacitated, your attorney can act in your place. Stands to reason that upon your death, you cease to be a trustee and you cease to be a director. Generally, the super fund deed then dictates who replaces you, if anybody. And this is an area that varies significantly, and it interacts with the constitution for your trustee company. It's a very complex area and it needs very, very careful consideration because the outcomes can be hugely varied and very, very important. Because if the wrong person or a person gets control of your super fund and you want certain things to happen, it's very, very difficult for anybody outside of that structure to force a different decision. So making sure the mechanism by which control is passed is absolutely key. You can't be a single individual person with a trustee of a super fund. So if you're a couple and you're the trustees of your fund, upon the death of one of the people, you have to either appoint a third person, which you can do. So the third person doesn't have to be a member. So you can appoint, quite often the case is a daughter or a son, and we'll come to an example about how that can go wrong. But if you can be a sole trustee of the company. You can be a sole director of the company. So the classic situation is generally if someone dies and one person's left, we'll generally appoint a trustee company with you as the sole director to continue to administer the fund. If you're proactive, you get in place a corporate trustee either from the start when you set your fund up, and I know Shari recommends that that's what people do. That's our recommendation as well. Or if you're an individual trustees at the moment, if you want to be, I guess, proactive, you can sort of sort out that issue so it doesn't become an issue upon your death. Generally, there's enough things going on upon your death that you don't. It's just one less thing that your beneficiaries and trustees executors don't have to deal with. An attorney of a member may be appointed as a trustee. I mentioned that before. So I guess the real message that I want to bring home is that control of the fund is absolutely key, because trustees have a lot of discretion under the trust deed. So generally a trustee can make all sorts of decisions which may not accord with what you want while you're alive. Once you're dead, obviously you can't make decisions anymore, and that person has a huge amount of power. So who controls the fund is probably the key component of estate planning now, and needs to be given a lot of careful consideration. Obviously, if a spouse or a child, say a spouse from a second marriage takes control of the fund, but it was the person's intention to benefit children from a previous marriage, if things aren't set up correctly, that can go seriously wrong. We see it happen all the time. It's a really big problem. There's a lot of cases that are now coming through the courts about this issue. And the general position is that the court won't interfere. They don't have the power to interfere. So there's no legal recourse to fix it if it goes wrong. So I mentioned the constitution for the trustee company because that obviously determines who can be appointed a director. So it's really key that those documents are looked through. Quite often the super fund deed will say, upon my death, my executors take control of the super fund. And then those people as executors have a lot of discretion about how the super is dealt with. Now, that person would be wearing two hats. They'd be wearing a hat as the executor, which deals with the estate assets, but when they're controlling the super fund, at that point in time, your super fund is not an estate asset. So it's not necessarily the same obligations, and there's a whole bunch of cases about the conflict of interest that suddenly brings about. So if I'm the executor and the will says it's divided equally amongst me and my two siblings, for instance, I have got a duty as an executor to call in as many assets as I can for the benefit of all the beneficiaries. If I then take control on my own of the super fund and decide to pay the super fund balance to myself, clearly that's in conflict with my other role as an executor. The position, there's two cases, and one says one thing and the other says the other. So at the moment, it's all a bit up in the air about that and how that's going to play out. So we actually deal with that specific thing. Well, I've started dealing with that in my will, making sure that there's powers and making sure that there's no conflicts between those two roles. So the message being your choice of executor becomes really important. So if you appoint one of your children as the executor and you've got three, that one child could take control of your super fund and make decisions which may not be in the best interest of all of your children. Or they might just be very honest, nice people and do the right thing, which I'm sure most of them are. The way to stop the trustee having discretion is to have what's called a binding nomination. So a binding nomination is a direction to the trustee, and I'll start to sort of move through a bit because I think I'm running, how am I going there, Shari? Yeah, 5 minutes. So they force the trustee to do what you say. So if you say, you trustee have to pay my superannuation to my children from my first marriage, and if it's valid, there's nothing the super trustee can do, even if it's being controlled by that spouse. Legally, they have to follow it. So then, those of you thinking through that, of course, what happens then is people disputing about the validity of the binding nomination. So if I'm the spouse and the binding nomination says give it to the kids from the previous marriage, I'm arguing that that's not a valid binding nomination and it's got some sort of defect, because as soon as that binding nomination becomes invalid, I control the fund, I pay the super to myself. So it's really critical. There's lots of cases going through the courts because really that's the only way that people can change the decisions that are being made. It's the only option for them. But if the court, as it does quite often, says too bad, it's valid, there's nothing that anyone can do about the decisions that person then makes. There's lots of rules about the signing of binding nominations, so they're really important to follow, otherwise they become invalid, and it's very technical. If a binding nomination lapses, it becomes a non-binding nomination, which basically can be ignored. That's the reality of it. I've never seen a super trustee really take much notice of non-binding nominations. So if you've got retail funds, if you see a name written on your sheet as your beneficiaries, it doesn't really mean much unless you've got a binding nomination in place. And the deed will dictate whether a binding nomination takes precedence over a reversionary pension. So that's another critical area. So sometimes the deed doesn't make it clear. So if there's a reversionary pension in place, which says it goes to the spouse, but then the binding nomination in place that says to go to the children from the first marriage, what do? We revert back to the deed, and hopefully the deed says that one or other takes precedence over the other, but you need to obviously check it because it's going to affect the outcome.
How do they expire?
Yeah, sorry, good question. I should have explained that in a bit more detail. So a lot of industry funds and retail funds, they're not self-managed, but other funds, they have got a standard rule that they lapse every 3 years. So that we see that all the time, that becomes a problem. Self-managed funds, it depends on the deed. So some deeds say that in relation to binding nominations, you need to apply the rules under the Superannuation Industry Supervision Act, and that will mean that there's an argument that says that they will lapse every 3 years like the other ones do. So you've got to be really careful. The deed is, again, the rule with estate planning is read the deed because they really do vary, and the outcomes are, can be significantly different. So in the couple of minutes that I've got left, I thought I'd just quickly take you through a couple of case studies. These are probably the two main leading cases, but we're seeing a lot more of these come through. So there was Mr Munro. He died and was survived by his wife Susie and 2 daughters from a previous marriage, Vanessa and Elkie. All 3 were executors, but Susie took control of the fund following Mr Munro's death, and to ensure the fund remained compliant, she appointed her daughter as an additional trustee, not the daughter of Mr Munro. Mr Munro had a binding nomination directing his death benefit to his estate, but on assessment it wasn't validly executed, and the court said that it could be set aside. So at that point in time, the discretion reverted back to the trustee of the fund, which was Susie and her daughter, and not surprisingly, Susie and her daughter decided that Susie should get all of the super fund balance. So effectively the court said, too bad to the 2 daughters. And this was a case, I can't remember the exact numbers, it was about $1 million in super and the estate was almost nothing. So basically the daughters got nothing. The other case was Katz versus Grossman. Mr Katz died leaving 2 children, Daniel and Linda. When his wife died, Linda was appointed as trustee of Mr Katz's super fund because obviously you can't have one individual as a member. So Mr Katz said, okay, well, Linda, you come and be trustee with me. As it turned out, a very bad decision. Daniel and Linda were both executors of Mr Katz's estate. Linda tried to appoint herself as a member shortly before her father's death. Really, when you look at it, for the sole reason, making sure that she could then appoint herself as the sole trustee. It actually turned out to be an invalid appointment because Mr Katz wasn't in a position to accept it. But in the end, that didn't actually matter. Following Mr Katz's death, she appointed her husband as the additional trustee. The court said she did that validly under the terms of the trustee, notwithstanding that she wasn't a member. The trustee allowed her, as the remaining trustee, to appoint her husband. And they obviously ignored the non-binding direct nomination because it became non-binding. And she paid the $1 million death benefit to herself, cutting out her brother. So I imagine their relationship may be a little strained at Christmas. That's all that I've got for now. I will be around, obviously, at the break if you've got any questions. I'm conscious of time and not keeping you here and taking up Shari's time as well. But yeah, if you've got a couple of questions.
If there's a change of federal government in the near future, can this all change?
No. Unlikely. I can't see any of what I've taken you through tonight changing in any material way. Yeah.
We're a pretty privileged group sitting around here. I just wonder, out there in the wide world, what percentage of people with super funds actually have any idea what a minefield it is?
Until they meet with me or one of my lawyers, most people don't have any idea. I would say, I don't know what the rest of my lawyers' experience are, but 9 out of 10 people that I explain this to them, obviously in an abbreviated form, have no idea that was the case. So it's a huge area of ignorance.